Okay, hello everyone. I'm Jennifer Grady and I'm here with Anthony Mance. We are both immigration attorneys at the Grady firm, and we're very excited to speak with you today because there are many different immigration issues that are happening, and we want to make sure that our clients and colleagues in network are aware of what's real and to distinguish between myths and facts. And so that's a little bit challenging sometimes these days, but our goal is to provide you with as much information as possible. And so I do see some of our clients on here, so I wanted to say a special hello. For some of you, maybe the first time you're seeing myself or Anthony if you're in remote offices around the country or around the world. So we wanted to say hello and thank you for your attendance here today. So the Grady firm is located in Southern California. We have offices in Beverly Hills, Newport Beach, and San Diego, California, and we work with our clients around the world. We specialize in business immigration, which would be employment and investment-based, and family-based for spouses and immediate relatives of U.S. citizens. So today we have a lot to talk about. If you have watched the news or if you follow Twitter, you may have heard that there is a proposed immigration ban that Trump has tweeted about in the last, I would say, 36 hours. And so we wanted to jump into that a little bit. Anthony and I were talking about it before the call today, since as you know, everything is hour by hour. Today is April 22nd. So for those of you watching the recording, this part may be outdated. So we do advise you always to follow up with uscis.gov. There they have press releases and news releases, and to look at AILA, the American Immigration Attorney Association, since those are the places that we go for real information. So we may start with a news article, but then we would always confirm it with a government sanctioned article, because just because we hear it doesn't mean that it's true. So that's the caveat for today. So this travel ban, initially when Anthony told me the night before last, I said, what is that? That's crazy. And then as we look through it a little bit more, it sounds like it may not be. And so, Anthony, tell me a little bit more about what we have heard this ban might be.
Um, so the most basic and kind of what probably at this point at least is the most accurate is it's going to be a restriction on people that are applying for permanent residency to the United States. So that would be somebody who either is going to be going for an interview to apply for permanent residency, somebody that's already gone to their interview and they're waiting to get their immigrant visa that would allow them to come to the United States, and then they would be issued their green card once they got to the United States, or somebody potentially who has an immigrant visa and is going through a process of getting their green card sent to them so they can come to the United States. So basically it's, from what they've said so far, is it's going to be preventing people who are applying for admittance to the United States as a permanent resident from doing that. There's a lot of questions. This was a proclamation that was made before they had really hashed out all the details. And currently right now it's going through a committee as part of the Trump administration. It would be lawyers, policymakers, things of that nature. And so they're working on a final draft of what will be an executive action.
Mhm. So we'll get into consular closures in a little bit, but for someone who's already abroad, perhaps they received an approved I-129 or an I-140, they couldn't actually go to do that interview anyway. So in that regard, this isn't creating anything that's new per se, other than that's already been happening for about a month or so. And so what if someone is already in the United States on a visa and they are intending to apply for a green card? How would that affect them?
Well, again, as I said, they really have not given any official notice about what this presidential executive order is really going to entail. But from what unofficial sources have said, it's not going to impact somebody that's already in the United States that's applying for a benefit. So if that does hold true, then if you're in the United States and you're applying using an I-5 adjustment status, you will be able to do that. You will be able to still adjust status. You will be able to go through that process. It will be processed by USCIS. The one thing that currently will not happen is you will not be able to go to your interview because all USCIS field offices are currently closed and they've suspended interviews. That part will not be able to move forward. Now, that's not part of this presidential action. That's something that USCIS implemented at the start of the coronavirus outbreak.
And so if you are doing an employment base where you have to apply for the I-140 first, that is a first step anyway. So you would do that now, and then hopefully by the time that's processed, the 60-day ban would be over anyway. So we have the two-step process, the I-140 and then the I-485. So would you say that people should still keep applying anyway?
Yes, I absolutely do think people should apply as long as USCIS permits them to submit applications, mainly because the way USCIS works is if you get an application in while it's permitted to submit an application, you're essentially in the queue. Now that can have various benefits. One, for processing, you're in the processing queue, so you're not going to have a delay once they start processing, or not as much of a delay. Also, in terms of the way that the Department of Homeland Security looks at whether you have incurred unlawful presence, if you get an application in prior to your current status being expired, that prevents you in certain circumstances from incurring unlawful presence. For instance, when you file a permanent resident application, adjustment of status, if you get it in prior to your current status expiring, then you are in a period of permitted stay in the US, in which case you're not incurring unlawful presence. So it is very important to continue submitting applications as long as USCIS permits it.
Sure. And so we would do that until we send it in and get it returned. And so really the only time we've seen things get returned were H-1Bs or H-2Bs, and that would be because of the lottery. So I think it's worth taking that chance. If you're on the cusp of getting your application done, I would say you want to maybe accelerate that. Obviously don't send it in if it's not ready, but if you're getting close, you may want to follow up with your counsel or give them whatever else they need to finish your application so that you can get that in and get yourself in line, because we do already see a lot of delays in the last year or so. And so we just imagine that is going to compound more. So what would someone do if they, for example, are applying for an L1 visa and they're abroad and now they have suspended premium processing? So how does that person plan their life moving forward when we have kind of no idea when things will be reopening and how long it will take to get an interview? So prior to this, we were seeing a 1 to 3 week wait time for consular interviews. So we would always factor that into the time before a client moves their furniture abroad or takes kids out of school, things like that. So now it's a little bit more challenging when no one in the world has any idea of when anything is going to let up. So do you have any thoughts on that?
I think it's a somewhat complicated issue because there's a lot of moving parts involved with this. First of all, if you're a petitioner, you're an employer, and you are petitioning for an L1 employee to bring to the US, you have to file that with USCIS. Premium processing has been suspended, so it will be the normal processing times. USCIS has continued and maintained their processing of applications that don't require in-person interviews. So they've said they've had their workers working from home, they're processing applications. It's too early to tell how much of an impact that's going to have on processing times. I think it's likely that, at least initially, productivity probably has gone down. But it's tough to tell how much that will be. But even if we're holding the same processing times we were looking at before the coronavirus, for an L1, I-129, normally processing times were anywhere between 4 to potentially 6 months. And so I think employers need to prepare for the possibility that it will take that long for a petition to be approved, in hope that premium processing is reinstituted. And the good thing about premium processing is you can file your application via normal processing times and then file a premium processing application after the fact, and then it will be turned over to premium processing. So as I said, worst case scenario is probably the best way to plan and hope for the best. Once the petition is approved, then the next step is for the applicant to actually go to the consulate or the embassy and apply for the L visa, which right now they can't do. And so one thing to consider if you're just getting ready to file a petition is when you need the person here. If you're going to file a petition and say, you want to have the person employed, 3 months from now, you may want to consider changing that to a little bit longer, because if you put, you want them to start working in August and they don't adjudicate the case until September, October, there's a possibility you could get a reduced approval time on the petition. So my assumption would be the best thing to do is to kind of give it some lead time. Say, for instance, if you're filing a petition now, say we want them to start working in 6 months or 7 months. And then in terms of the consulates and embassies, they're basically saying now that they're going to be closed indefinitely. And I think they're going to open up depending on the specific country conditions. And in terms of wait times and backlogs once they do open, I think that's also going to play into the size of the embassy, how many people are applying for that specific category. So if you're at a very busy one like London or Paris, there's probably more of a backlog than if it's a smaller embassy, in a smaller city. So really planning for time is important. But right now, talking to your employees overseas and telling them, look, we're going to file the petition, you're going to have to wait, but keeping in contact with them, watching what the State Department does so that as soon as they open, you can file the DS-160 and schedule the appointment.
And so advice that we had already given clients before all of this was to always check back for cancellations. A lot of times people had been able to get an earlier appointment, especially if they were in a rush to get here, or to check other consulates or embassies to see if they have a better wait time. So you can look at that when you're filing the application to see where would be the best place to go. So so I guess this is a little challenging. So if you had already filed and now things are dragging on longer, like for example, an L1A, what would you do about that start date? Can you amend it? Can you have more time? Because usually once they give the approval, that's when the time starts on your either 1 year if it's a new office or your first 3 years.
Sure. That's unfortunately something that has not been specifically addressed by the Department of State or the Department of Homeland Security. I think if you filed your petition right before all of this happened and they give you a approval time of, let's say that started, in June, and they don't open the consulate until August or September, then you would lose time on that and you would be required to extend that later on. The bigger question is, for instance, if you just filed an application, let's say a few weeks ago, and it's going to be processing for the next 4 or 5 months, what's going to happen in that situation? Department of Homeland Security may coordinate with the State Department. My feeling is probably not. Just practice usually is there's not a lot of communication, so likely it's going to cut into the time and will require you to extend that. Now, one thing I would say is L1s and H1Bs have a set amount of time that you can work in the United States, and that doesn't change. So if you ask for 3 years on an L visa and they give you, 3 years, but you actually can't come to the United States until, let's say, 2.5 years or half a year into it, you can recoup that time next time you apply for an extension. So.
Okay, great. So now let's talk a little bit about, well, just one quick thing about RFE. If you get a request for evidence or a notice of intent to deny between March 1st and May 1st, 2020, there is an additional 60-day grace period on the time that you can do that response. And then also now for a brief period of time, they're accepting digital signatures on applications instead of wet signatures. So while we have these kind of grace periods and additional benefits, I think we're not taking advantage of those. We are still asking our clients to send in wet signatures. I'd rather just have the application done correctly. And then for the RFE response, I would say unless there's a reason why you have to delay. For some reason you can't get in touch with your counsel, or your company's closed and you can't get your information, I would say to just respond within the deadline anyway. I mean, we always try to get those done ahead of time, because the sooner you get your answer in, the sooner they'll move back to adjudicating your application.
And I think that's an important point too, Jennifer. When you get an RFE, they stop working on your case. It's essentially just sitting there. So the longer you wait to submit the information they're requesting, the longer your case is going to take before they finally do an adjudication. So it makes sense to get in as soon as possible.
Mm-hmm. Yeah, so again, only have those there for real necessities. Okay, so now let's talk about how does employment affect immigration. So we do both employment and immigration law, so we've been working together as a team on a lot of these questions where people are getting furloughed or laid off or their hours reduced. And so for certain visa types, that may be more of an impact than others. So I want to go through those one by one. So let's start with our students. We have people on OPT or CPT or an F1 visa. So F1 is the student visa. CPT is if you can work while you're in school. And then OPT is a year to 2 years after, depending on your degree type. So let's talk a little bit about that. Tell me, what would a student do if their school is closed due to coronavirus and they can't attend classes?
So a lot of universities have gone to virtual classes, so people are working remotely. And ICE, Immigration Custom Enforcement, which does a lot to deal with the schools and enforcing that, and then USCIS as well, have given a lot of flexibility in terms of F1 visas and how people can maintain their status. If a school closes and they're not offering classes and effectively the student is not performing any kind of academic function, then they are likely out of status and would have to change to a different status. If the school is still functioning and offering classes, then they're usually fine, and basically they're maintaining their F1 visa in the same capacity as they would if they were actually attending in-person classes.
And so if their school for some reason was not operating, and you said to change the status, what would they change it to?
It really depends on what options they have available. It may be a B2 visa, which is a visitor visa. It may be a F1 visa with a different school. If they can transfer to a different school and, that is allowing virtual classes, or some other way is still providing the academic services, then they could do that. There may be an option for a J1 visa, exchange visa that permits essentially employment. They may have an opportunity to apply for an e-visa. It really depends. I mean, it really comes down to what they're qualified for and what they have the capacity to apply for. The important thing is they need to switch to something that, number one, they can switch to quickly, because every day that they're not attending classes is a day that they essentially are incurring unlawful presence. And also something that is reasonable. You can't just apply for a change of status to something that you had no chance of actually getting, because the government will say that that was a frivolous application and essentially will probably deny it, and may then look back and say that, well, you were unlawfully present the day you submitted this because you knew that there was no way that this was going to be approved. So you want to be careful about what you apply to and not just apply for something that, just for the sake of applying.
And remind us what the unlawful presence rules are.
So unlawful presence essentially means that you are in the United States without having a status and without having some other permission to be temporarily in the United States. And every day that you are unlawfully present in the United States is counted against you. Once you hit 6 months, you get to what is called a potential bar to reentry in the United States, meaning that if you're here for 6 months, then you can be barred from coming back into the United States for up to a certain period of time. And then if you're here for a year out of status, it extends that time. So you're looking at 3 and 10-year bars. So you really don't want to do that, because it would prevent you from coming back to the United States. Also, it can expose you to being deported and going through deportation proceedings. So it's really something you want to avoid. Every day of unlawful presence you want to avoid, but you certainly want to make sure that it's under 6 months.
181 days. Now we have that 3-year bar. After 366 or 67 days, now we have a 10-year bar. And people do end up having that. And I've seen ones where they are waiting, and after the 10 years, then they try to come back. But I mean, that's such a long time. We don't want you to end up in that situation. So if you have a status coming up in the next 6 months, it's probably a good time now to speak with an attorney and figure out what you're going to do. So we had talked about maybe switching to a B2 is the most maybe obvious, but keep in mind that does not allow you to go to work or to go to school. It's just a visitor, so you're allowed to be here in a status, but you're just kind of hanging out waiting for something to happen. So that can take a few weeks to process, Anthony. We're at end of April, schools end in May or June. What would you recommend? How long do you think that might take to do the process if they were to switch?
So if you, for instance, if you're on an F1 visa and you want to switch to a B2 visa, processing times prior to the coronavirus were, again, 4 to 7 months. In some cases, it really depends on the complexity of the case, the adjudicating officer that receives it. But I think the important thing to remember is that there could be delays for this. Now, the way that immigration law works is if you submit an application for a change of status, then once your current status expires, you technically have 180 days where they effectively are forgiving any kind of unlawful presence, meaning that if they deny your case within that 180 days, it's essentially they just say you have to leave the country, but you don't incur any unlawful presence. After that 180 days, if they're still adjudicating the case, they have the discretion to say that you are incurring unlawful presence or not. So usually what happens is if it takes more than 180 days to process that, and then they approve it, they just ignore any kind of unlawful presence after that 180 days. If they deny it, that's where it could become a little bit more challenging. And that's why it's really important that if you are applying for a change of status, it is something that's realistic, because if they were to deny it, you could incur unlawful presence, after the 180 days.
Right. So if you have a status, again, coming up within 4 to 6 months, I would say, figure out ASAP what you're going to do, because the other issue is that now, due to the travel ban, people can't leave. And so that's another topic I wanted to address. And that's, what if you have to leave soon, but you can't actually exit? And so we had talked about extending your status. And then if you're on ESTA, then normally you can stay in the US for 90 days. But now if you can't return home, you'd have to go to the Customs and Border Protection Deferred Inspection Office and request an extension. So we had talked about that a little bit before. We'll just briefly touch on that. So where does this office exist, and how long is that extension for?
So they have various offices around the country, usually in larger cities, sometimes at airports, ports of entry, places like that. What I would advise first is calling them. So if you go to the Customs and Border Protection Office website, or if you just Google deferred inspection, you can find a phone number that you can call and you can start that process. In some cases, they may not make you actually come in for a in-person meeting. They may do everything over the phone, over the internet, but you'd want to call them, and you'd want to do that, before your period runs out. Don't do it after your 90 days runs out, because once you've reached 90 days, you're incurring unlawful presence, and it may take some time to process. So I would say if you're at 70 days, it's a good time to probably contact them and say, hey, I have 20 days left, but I don't know if I'll be able to leave. My country is not letting me return. And likely they're going to want to see some proof that you intended on leaving after 90 days. So they may want to see your original plane ticket showing that you're leaving, or any other evidence that shows that your intended stay was limited to 90 days.
Okay, so again, preparation is key right now, since we know there's delays. If you have anything that you're not sure about, you can give us a call. Also, to schedule an emergency appointment or ask about your case, you can look at the USCIS Contact Center, and that is at uscis.gov/contact center. There's an 800 number you can call, or you can also send, I believe, secure messages that way as well. So let's get back to employment-based, since we have a lot of employers on this call. We have furloughs and reduced hours. And so we've actually gone through these scenarios with a lot of clients that either have to reduce employees down to 0 hours or 24 or 32, or maybe even lay them off. So let's talk about each visa one at a time. So how about the L1, J1, and O1? What would you do if you have to reduce those hours? Is there a certain threshold which we should keep them over?
Yeah, so the most important threshold to remember is that you have to maintain the status. That means that if you're on an L1, J1, O1, you have to continue doing the activity that you was originally petitioned for in the case of the L and the O visa, or was part of the training program that was, associated with the J1. So the work has to continue, essentially. There is flexibility in terms of reducing hours and in reducing pay because those visas don't have a labor condition application associated with them. Reducing pay, it's kind of a gray area because there really isn't any specific guidance on that. But what most common understanding right now is that you don't want to reduce the pay down to the point where they're no longer the type of employee that was petitioned for. So if you're on an L visa and you're filing for a full-time employee or a permanent employee, you may be able to reduce them down to what we consider to be part-time hours, but you don't want to reduce it below that to the point where they're no longer a permanent employee. And that comes into essentially state and federal employment guidelines. So you really want to continue doing at least part-time work in that situation. The other consideration, back to what I initially said, was if they can't perform the function as petitioned part-time, then you really want to consider how low you drop those hours. So you don't want to reduce them to the point where they can't perform that work anymore. And then in terms of pay, it's reducing it to what's reasonable. So, obviously you may have to reduce the salary overall, and that may be permissible, but you don't want to reduce it down to such a low level that it no longer is reasonable for somebody in that position. And you certainly don't want to reduce it below minimum wage for the state, because then you're getting into employment law issues with that. So.
Yes, so I will touch on those. So also another thing to keep in mind, if you have some of these people are in more high level exempt positions, so if they're a supervisor or a manager, if we are reducing their salary, so for an exempt person, they're paid the same amount every period, so we would be notifying them the pay period before if we're changing it, and we would reduce their salary by a certain percentage as opposed to the number of hours. And we have to make sure that to keep that exempt status, they're still earning the exempt salary. So in California, it happens to be double the minimum wage. So I think it's at least $10.54 per week. And then in other states, it's lower. So you would check that. We've made a chart of that. We can share that with you. And then you have to make sure that they are still doing their exempt duties. So for example, in California, that would be supervising at least 2 people using independent judgment at least 50% of the time. But on that, there are wage orders for each different type, like professional, administrative, exemption, and so you'd have to check the wage order, make sure they're still doing that. And I bring that up because if people are either working less or working from home, that may impact their ability to continue doing those duties. So that's just something to keep in mind. But also, number one, if you take away nothing, is don't lay off someone on a visa, because then they're now going to be out of status. And so, for the O1, we would say, like, don't go below part-time, I would say, for all of these visa types. I think that's going to make it complicated because we are telling USCIS when we're applying that you're going to be doing a full-time job. Look back at your application to see what you told USCIS you would be doing. You want to make sure you're still doing those duties. They may be in a reduced capacity, but you still want to be doing what you said you would be doing.
And another consideration too is the work location. So for O1s, L1s, and J1s, there is the possibility of altering the location where the employee works. So in most cases right now, probably working from home. That is permissible provided they can still perform the function from home. In terms of an L1, because if they're in an L1A, they're in a managerial position. It means that they can still effectively manage subordinates or the function of the company that they're going to be managing. If it's an L1B, it's maybe a little more simple because they're going to be in a specialized role. That might be something that can be done from home easier. You just really want to make sure that, USCIS may never get involved, but if they ever did, you'd be able to show how they're able to perform that function. Another consideration too to bring up is the J1, because the J1, unlike the O1 or the L1, is mainly administered by a sponsor, a sponsoring organization. So when you applied for the J1 initially, you would have gone to the sponsoring organization. So any changes that are made to a J1, you should contact the sponsor first and get their approval, have them look at it, because what they need to do is they need to then tell the government, if necessary, that the employee is actually still getting the training that you initially petitioned for or applied for. And if they're doing that from home, they want to show that, yes, the guidance is still there. Yes, they're still able to do it because they had such a significant training element to it. So that's important to communicate early and often with the sponsor to make sure that they approve it, they know what's going on, and they have all the information they need.
Along those same lines, for students who are working on CPT or OPT, you would want to check with your school if you have any changes, maybe have that conversation. I would say don't just change your employment without speaking either to your school, your sponsor, employer, and your attorney as well. Okay, so now let's get into H-1Bs, because those do have pretty hard and fast rules that we want to make sure everyone is aware of. Basically, we've advised people not to touch those jobs if you can. If it's only a few people out of your company, may not be worth putting them, reducing their hours. So Anthony, please tell us why.
So the H-1B comes with some very strict guidance, and a lot of it falls on the labor condition application that is required to be filed with the Department of Labor prior to filing your petition. And that labor condition application essentially is the company attesting to the fact that they're going to be paying a specific salary to the employee, that salary is above the prevailing wage, and that the employee is going to be working in a specific geographical area. So all three of those functions play into any kind of changes in employment. So for instance, if you want to reduce that employee's salary, if it's below what was on the labor condition application, then you're running into a situation where you would have to file a new labor condition application. And if you have to file a new labor condition application, then you have to file an amended petition with USCIS. So it does have some pretty significant consequences. One area of flexibility, and maybe a small one, is if on the initial labor condition application and petition you had a range of salaries. So for instance, if you had the low end being the prevailing wage and you went up by $2,000, then there may be some flexibility in there in terms of the annual salary that you pay the person. You can reduce it as long as you don't go below what was the low end on the labor condition application and the petition. So that's pretty hard and fast. Now, in terms of work location and hours, again, you can't reduce hours without it being a substantive change to the petition. Therefore, that would require a new labor condition application and ultimately would require a new amended petition. So reducing hours is probably also going to be very challenging just to do without any changes. The one area where there's a little bit of flexibility is going to be in work location. If the employee is working from home or at a different location and it's within reasonable travel distance of their stated place of employment, so the address that was listed on the labor condition application and the petition, then they're permitted to do that without any change, without a new labor condition application and without a new petition being filed. Now, what normal distance means is a little flexible. what USCIS and the Department of Labor have essentially said is if it's the home address where the employee normally works, and so that's their normal commute, then it's probably okay. Also, if it's in the same metropolitan statistical area, then it's automatically assumed to be a normal commuting distance. Where it becomes a little more challenging is, for instance, if you want to have the employee working at, let's say, a satellite office, and let's say that you are in New York City, the employee normally works in the city, and you have a satellite office in New Jersey. That gets a little more challenging, because unless it's within what would be reasonable, 50 miles, it's probably going to be outside of the normal commuting distance and would require a amended petition. There's another element that sometimes can come into play, and that's a short-term placement, meaning that if it's something under 60 to 90 days, it may be okay. Now, I would caution against that, simply because the Department of Labor has been kind of vague on what they consider, a temporary placement. So if that's something that comes up, if you have to have an employee work from home for a week and, it's outside of a normal commuting distance, it may be okay, but anything longer than that, or even if you can prevent that, I would say don't do that. Try to keep them within their normal commuting distance. So that's the one area of flexibility. Aside from that, if you have changes to hours, if you have changes to salary for an H-1B worker, it's likely going to require a new labor condition application and an amended petition.
And do we like touching applications once they've been approved and somebody is working?
No, especially, so this goes back, gives a little bit of a history lesson. So prior to 2017, USCIS had an unofficial rule that essentially said that if you were filing an extension of an existing application or an amendment to an existing application that had been approved, they adhered to the initial decision, meaning that they would not really give those cases a hard time. They would approve it, provided there was no serious substantive changes. That changed in 2017. Now, every application filed with USCIS is deemed to be a new application. So one that was initially approved, even if the only change is reducing the hours by 2 hours a week, they're going to look at it from the start, and you may get an officer that's harsher, and you potentially could get an RFE or even potentially a denial. So we try to avoid that if we can. Also, if it was an application that was initially filed and you're reducing the salary significantly in an amended petition or reducing the hours, that could change the way that the officer views the application and could be risky too. So we really try to avoid it. Now, sometimes you can't, and I think our advice would be, if you have to file an amended petition, make sure that on its face by itself that it is approvable, and don't just kind of adhere to and fall back on what the initial petition adjudication was.
Right. Mm-hmm. So I would say in the last few years, every time we do any amendment or anything, we're pretty much doing it over. It's a lot of work and a lot of time, and you still get an RFE. So that's why, if I would say, take away, if you don't have to touch it, don't. But you have to, if somebody has to work from home and they're outside that kind of 50-mile radius. We did have someone who lived in Texas and wanted to move back with his wife in California, so that would actually require an amendment. And if you even had a DUI or anything like that, like, we don't want to keep putting things on USCIS's radar if we don't have to. If you can leave things alone for people who are already here, I would advise that. But if, for example, like, the office is closed, somebody happens to live, an hour or two away, now they're working from home, then that's something that we would discuss with you to see if that's something that we should amend.
One final consideration too is, if you have to file an amended petition, one thing to keep in mind is, if, for instance, let's say that you're reducing an employee from full-time to part-time, and you file an amended petition, and the processing time, because we don't have premium processing, is 5 to 7 months. You can't, if in 2 months things go back to normal and you want to withdraw that application, it can be challenging to do that, because what USCIS is going to say is that, well, you reduced that person's hours and then you withdrew this, and so you effectively changed their hours prior to us adjudicating whether it was okay. Because under H-1B and L-1s, if you file an extension application or an amended petition, then you are permitted to immediately change the employment as soon as it's received by USCIS, and you can continue to do that for 240 days. So we're really not sure how USCIS would come out on that, but it is something to consider, that they could come back and say, well, you never had this permission to do this because we never adjudicated it. So it is to be avoided if you can, and if it can't, you probably want to let it play out until the end. So now, one thing I would say is, if you reduce the hours and you file a petition, and later on you can increase those hours back to full time, you let the petition play out and you just increase their hours and their pay, because USCIS is not going to punish you for paying the person more. So likely that would.
Okay. Okay, so we do actually have from the audience, and if you haven't entered one, you can go ahead and enter it in the chat box, but one specifically related to H-1Bs. So let's talk a little bit about, if you have filed one for application, what's there. So we filed those before March 18th, and by March 31st, they put notices in the flag portal saying whether it was submitted, selected, or denied. And so if it didn't make it through the lottery, currently it would be showing as submitted still. Is that correct?
Basically what happens is it'll show submitted, and then we'll have under the status just N/A. And that effectively means that it's open for decision, but because they've already filled the quota, it's just, they're keeping it open in case later on there's a change and more visas become available.
And so keep in mind that we're always trying to research this lottery and figure out if there's a method to the madness or what's behind it. And I think part of it is they have to make a decision up front how many they're going to allow, and that's why sometimes we'll submit applications and then a few days later they'll say, oh, this is closed. I mean, with H-1B, we always submit them before the deadline, but for some more fluids that don't have a deadline, they may come up with, we denied, or we closed premium processing. So one thing to keep in mind is that H-1B premium processing, they pretty much suspended every year in the spring because of the H-1B application process. So the new one for this year would be like for the L1s, for the I-140s and the I-129s. But as this goes on, people may drop out because their application was denied for, meritorious reasons, or maybe they didn't have everything done correctly. I know they do a preliminary search at the beginning of to make sure it has like a few basic things before it gets moved on. And in this year, there were only so much information you could apply. It was different. So Anne here wants to know if there's a delay in the H-1B lottery results. And the other thing that you and I had talked about before was that now maybe companies might not be able to sponsor someone if they are shutting down or other impacts due to coronavirus. So it's possible that may open up some spaces between now and October. So do you have any other thoughts on delays in the lottery results?
I mean, in terms of the lottery itself, I mean, I think they've completed it. They've got their application. So I think the next issue is going to be waiting to see what happens, because if someone was selected in the lottery and they file a petition and it's ultimately denied, that could open up a new H-1B that somebody else then could get. The other thing to consider too is the way that the system works now is you're given a period of time, essentially 3 months, to submit your application. So people may have gotten selected for the lottery, and then because of what's happened with coronavirus, the employer is no longer able to do it. I know I spoke to somebody who was selected in the lottery, and their employer is a small business, and they're not sure what the situation is going to be like in 2 to 3 months, whether they're going to get the government funding they're looking for, and whether they'll have the capacity to hire the employee. So they're kind of taking a wait and see approach as to whether they'll even be able to file the petition. So there's a possibility, in a month or two, that enough people, don't submit their applications, and then they have to reopen the lottery and select some more people. It's tough to tell at this point, but I would definitely say it's worth checking the online portal regularly, just in case, to see if anything changes. Plus, they also send emails out, so you would get an email. But it's probably unlikely, but there is a possibility. So it's worth looking
And the
into.
reality of that is that this lottery happened before a lot of the closures, and I know every day there were rumors that people were selected, and we really didn't take that seriously until March passed. So I would say, keep an open mind. There may be a possibility. It's kind of like applying to college. Some people may get, okay, you're off the wait list the day before, now move your life and come to start school. So I think that's how this will really play out. So if your application wasn't selected, and again, I think it was between 270, 300,000
Mm-hmm.
applications for, it's really like 81,000 spots because of, or less because of the H1, which comes out of that 85,000. So I would say if you haven't heard anything by now, it's time to start thinking about other options. And so some of those would include the E2, the L1, the O1, EB1, E3, and TN. And so some of those are country specific, like E3 for Australia, TN for Canada and Mexico. O1 if you have extraordinary ability in arts, business, science, motion picture. EB1 is if you can self-sponsor for green card. L1 is if you are working abroad and can come here as a transferee. And then the E2 would be business investor visa, although we still have the issue of consular interviews being suspended definitely right now. So kind of few other things that we would say every year if you don't get selected for the H-1B to look into alternative options with your attorney. Okay, so then we have another question which touches on what we talked about earlier, and this is maybe just wrap up all the things that we said. So he wants to know if he has an H-1B1 that expires in June and cannot return home, in this case it's Chile, what should he do? Apply for a change of status, another type of visa, and what happens if we get to June and nothing has been changed and now he's going to be out of status?
So if he applies for a change of status, frankly, what I would suggest in that case is waiting till he gets closer to the expiration of his current status, and then file, for a B2 visa. And then, as I said, processing times likely are going to be, 5 months at least before you get a decision on that. And that would give you time to remain in the United States without incurring unlawful presence while you're waiting. And if, Chile or whatever country is at issue here opens up again, then, you can just leave and it's not going to negatively impact you if you abandon that application. You'll lose your filing fee, but, it's not going to hurt you in the future in terms of applying for a new status. That would be the best advice. I think, B2 is a good option. And on the application, you just say, I was on, an employment-based status. I, could not renew this. I needed time to wrap up my life. In addition, I could not return to my home country. So I'm asking for an opportunity to essentially become a tourist and stay in the United States and essentially wait this out. Obviously, USCIS knows what's going on, and they're going to get a lot of applications like this. So I don't see them saying that's not a reasonable basis for staying in the U.S. So that would be the advice. Now, if there's another status, for instance, if you can switch to an e-visa or something like that, that may be a possibility as well. But I think probably the easiest is going to be the B visa. But, just to keep in mind, you cannot be employed. There is, in some circumstances, if you're in an employment-based status and you want to continue to interact with, your employer or with clients, you could potentially apply for a B1, which would allow you to attend meetings, do other limited business-based functions. You just couldn't be gainfully employed, meaning you couldn't do something you're getting paid for. But it would allow you to interact with employers and things like that. A good example is I did speak to somebody who was here is here on a H-1B, and they're thinking of opening their own business and applying for an e-visa. So they were considering because they can't go home, applying for a B visa and saying that they want to be here so they can, explore options for buying a business in the U.S. So, I mean, those are unique, specific situations. But the bottom line is, you do want to apply for something that will hold you over so that you're not incurring unlawful presence while in the U.S. Because right now, the Department of Homeland Security is not going to waive unlawful presence simply because you can't come home.
Okay. And so what about applying to renew their current status so they can keep staying in employment?
Yeah, so I mean, if that is an option, meaning that you haven't reached your maximum time in the U.S. on that status, so an H-1B, for instance, your employer can apply to extend that, and once they've submitted the application, it's been received by USCIS, you're permitted to continue working for up to 240 days or until they make a decision in the case. So if it takes them 230 days to approve it, and then it gets approved, then you have continuity of employment. If for some reason it was denied, then you'd probably have to leave the U.S. at that point. But it will allow continuity of employment, so that's kind of the most important part of that. So definitely, if it's an option to extend your existing status, I definitely would say that would be the most advisable solution.
Mm-hmm. Okay. And then the B1 is something that we use for people who are interested in the E2, and that's the investor visa, where you'd have to be part of a treaty country and invest about $100,000 in a U.S. enterprise. And so if someone was abroad and they wanted to come here and sign contracts, look at lease agreements, make business partnerships, they would do that on the B1. So that's something you could consider, but keep in mind, if you were already working, you'd have to stop that work on a day-to-day basis. And so this is really something very nuanced. I'd recommend you give us a call and we can talk about it if that's the situation that you're in. Okay, and so let's talk about unemployment benefits. I think that's probably on everyone's mind. If someone is a visa holder or a green card holder, can they apply for unemployment benefits?
It really depends on the state. Normally, no, mainly because most states, the way that unemployment works is you have to be able and immediately available to accept alternative employment when you're on unemployment. And obviously, if you're in a visa category that is specific to one employer, such as an L1 or an H1B, you're not permitted to do that. Some states, including California, have expanded their unemployment during the coronavirus, to allow people who are on non-immigrant visas to apply. And there are specific rules to go through that process. And so it's worthwhile, depending on your state, to look at what that specific state is doing, in terms of coronavirus response, to see if there is an opportunity to do that. If you have unrestricted access to work, so for instance, let's say that you are on an L2 visa, so you're the spouse of a L1 visa holder and you have an employment authorization card, you can work anywhere. So then you could apply for unemployment because you have the ability to immediately take new employment if it becomes available.
So I'll clarify on that. So if somebody is laid off or terminated and they're on a visa, can't apply for unemployment. So even though they may have paid in, because they're not in California, the rules are ready, able, and willing and available to work. And so if you don't have a status now, you can't work, so you're not available to work. So then the caveat for COVID is if you're getting reduced hours, they had it so that you're kind of available to work for your employer. So that's how you can apply for unemployment in this context. If your hours are reduced and you're applying for unemployment to fill in the gap of those hours, because it's for your business. So just one little employment note, it's still kind of undetermined if somebody is choosing to stay home because they are scared of COVID, but they don't have a doctor's note and they're not really qualifying for anything else. That may not actually be eligible for employment because you're not ready, able, and willing to come to work. So that's some nuances. These things are kind of changing and evolving. California has the EDD, Employment and Development Department. Go to that website. They have a Q&A on COVID, lots of information there, kind of looking at daily. That's what I would recommend. And if you have other questions, just give us a call. Okay, so then lastly, the COVID impact on the PERM process, and that people applying for a green card or for something like an even H-2B where we have a recruitment process, how is that being impacted?
So from the standpoint of adjudication, Department of Labor is still adjudicating PERM applications. Department of Labor is still issuing prevailing wage determinations. I have heard of some evidence that they may be delayed in terms of processing somewhat, even though they also are working from home. It may be down to productivity. It may be down to something, internally, but there may be some delays with that. I think the bigger issue is going to be pre-filing of the permanent labor application in terms of having to go through recruitment, because you've got a situation where you have to post the job notice at the place of employment so everybody can see it. Obviously, if your offices are closed, that makes that challenging. Recruitment could be challenging if you need to do in-person interviews because it's probably precluded. So what Department of Labor has essentially done is they have extended the 180-day period from which when you start recruitment to when you have to file the PERM application. They've extended that out as long as you fall into a very kind of specific date period. So if you started the recruitment between September 15th in 2019 and March 13th, 2020, they're extending the 180-day period to 240 days. That means you have 240 days to file the PERM application. Now, one thing to keep in mind is you still have to follow their rigid guidelines. So you still have to do most of the recruitment in the period 30 days before filing the PERM application. And you have to still do the 10 days of posting the application now, or the notice of the application. There's a little bit of flexibility in terms of how they're going to allow it to be posted. So it can be electronic. You still have to post it at the place of employment. So that's something to consider. The other issue is,
if your office is totally shuttered, do you have to go in and put it there in a room that no one's going to see it?
I would advise that. I would, just to be safe, and also, post it electronically. The important thing is to make sure that all employees see it and be able to demonstrate that you showed all existing employees that are similarly situated that this job was being recruited for and that a PERM application was going to be filed. So
if you do have a server, we say put it there in an online server, or email everybody and keep a copy of that. And then when you do your postings of the job ads, we always have our clients take a photo of where it is with the time and date stamp in case you're audited, then you would have that. So there may be more flexibility, but kind of have to keep moving on and doing what you need to do. In terms of recruiting, it may be more challenging depending on the job because a lot of people are out of work. I've heard there's even 20% unemployment rate right now, so you may get more people applying, which could affect the recruitment process, although you do have to make sure that they're qualified for the job. A lot of people may be just passing resumes around just to get unemployment or just to do that. So tell us how does that affect the recruitment process when you do get candidates who are minimally qualified for the job? And so that doesn't mean you can't hire them because they don't meet your company culture or personality. We're going to be looking at whether they actually meet what you're posting in your job ad.
Yeah. So basically for the PERM process, when you're recruiting, you have to give the potential U.S. worker the same information and opportunities that you would for the foreign national worker, meaning that anything that you're going to offer to the person you want to hire, the foreign national, you have to also show to potential U.S. workers that they have the same opportunity. And in terms of qualifications, if a U.S. worker applies who is minimally qualified, meaning they meet the written job description, qualifications, requirements, things of that nature, then they can effectively stop the process. Now, if you interview them and you just don't think they fit with your culture, or if there's something small they don't know but they could learn on the job relatively quickly, then you can't use that to preclude them. It can only be legitimate business related reasons for precluding somebody from the process. And if a minimally qualified person does apply, you don't have to hire that person, but you have to stop the entire recruitment process and essentially start over at a later period. Where coronavirus could become a challenge moving forward is, number one, there's going to be a lot of people out of work. So there may be a lot more people applying than normally would during the recruitment process. And you may have a more challenging time of not finding a US worker who's minimally qualified. The other issue too is, even if you don't during recruitment, depending on the industry, there's a possibility that the Department of Labor will take a more strict view, maybe more suspicious view of, whether you actually did find anybody who was minimally qualified. It could mean more audits. It could mean that, they simply just give you a harder time in terms of adjudicating it. We don't know. We don't know how that'll play out. I think a lot of it will depend on how quickly the economy rebounds, the specific industry you're in. If there's, in the news, there's a lot of talk that there's a lot of available workers in a specific area for, a job that maybe, a lot of white collar jobs and jobs in the financial industry, things like that, where there were a lot of layoffs, you may have a more challenging time. But again, that's something that, we just kind of have to wait and see how things play out. But I think the important thing right now is to remember, if you're going to start this process, that, you want to make sure that you lay out everything that is required and you have every one of your requirements written out, so that, you basically cover all the bases when it comes going through this process.
Mm-hmm. Okay, so I have one more question. If anyone else, this will be the last one, unless anyone does have another question, please feel free to enter it in the chat box right now. So one question just said, I may have missed it, but did we talk about the order limiting immigration? So just to summarize on that, there's no order yet. It's still preliminary. That could change in the next few days. But from what we've heard, the goal was to limit people applying for permanent residence. So that does not mean don't apply for your green card right now. You may have the I-140 first, then your I-14085, but this is really what we assume is targeted at people abroad who may have already had an approval, and then they want to go to the consulate to get that visa, that stamp in their passport so that they can actually come here. So we think that that's what that is. Again, doesn't count until it's official, so keep checking on the USCIS.gov website. They have press releases and news releases, and then AILA is the Immigration Attorney Association that usually is pretty well connected to all of the news and sends us issues. So if there is an update, we will publish a blog, put that in our newsletter, or you can follow it in the news and then ask us to confirm whether we think it's true, because right now we're really dealing with news articles, and that's my first choice for sources. So that's kind of the summary there. So if no one has any other more questions, Anthony, it's trying times for everyone in all directions. What would you say is kind of the takeaway and kind of a positive note to leave everyone with?
I would say that the most important thing to remember in terms of the immigration front is immigration is, for the most part, still operating in the sense that they're still filing petitions, they're still adjudicating where it doesn't require in-person interviews. And the other thing I would just say is, it's a constantly moving scenario. Things are changing all the time. The government has been slow to meet the issues, but they are in certain circumstances, especially the Department of Labor has, made changes that have been beneficial given the circumstances. So I think the most important thing right now is just to remain educated, make sure that you get information before making any decisions. And I think as long as you know what you're doing, there may be options. It's just, you just don't want to act without, getting the proper information. So, right now it's the most important time. It's always important with immigration to be educated and making sure that you know all the policies, all the rules, and making sure you follow those. But I think it's even more important now to make sure that you're keeping up with changes that are happening all the time with what's going on right now.
Okay, and on my end, we're still processing cases as usual, still getting those submitted. And so if you're on the fence about whether to do it or not, get that in, get it in the queue, because we do for sure anticipate delays in processing times. you kind of have to plan your life a little bit farther into the future more than normal. I mean, if you're someone who's changing immigration statuses, you've been here for years, you've done the alphabet soup going from one visa to the next, you really want to give us a call or give your attorney a call and figure out a plan with different contingencies. So if this doesn't clear up in the next few months, what would I do if this, then that? And so that's something that we would walk through with you to make sure that you're kind of have the best position that you can be in. So, and then if you do have any follow-ups, you can email us at info@gradyfirm.com. You can schedule an appointment on the schedule portal at gradyfirm.com, or you can call us at 949-798-6298. So this is Jennifer Grady and Anthony Mance. We're signing off. Thank you guys for your great questions and your attention. And we will maybe do another update in a few weeks if we have some significant changes. So thanks and have a great rest of the week.
Have a great day.
Bye-bye.